Good morning, Mr. Horowitz, Mr. Wallace. I will call the next case. People versus Victoria Pagano. This is a full 20-minute grant. You each have 20 minutes. Mr. Horowitz, you may reserve time if that works out for you, and you may proceed when you are ready.
I would excuse me, good morning, and I would reserve, if possible, 5 minutes. May it please the court. In his dissent in Navarrete v. California, Justice Scalia cautioned us that drunken driving is a serious matter, but so too is the loss of our freedom to come and go as we please without police interference. To prevent and detect murder, we do not allow searches without less than probable cause or targeted Terry stops without reasonable suspicion. We should not do so for drunken driving either. In that case, the United States Supreme Court affirmed in a 5-4 decision the propriety of a traffic stop based on a report that the driver had run another driver off the road. The anonymous tipster reported that at a particular location, a particular vehicle, quote, ran the reporting party off the roadway and was last seen approximately 5 minutes ago. Officers responded about 15 minutes later, stopped the truck, and ultimately found some bales of marijuana. The initial question addressed by the Supreme Court was whether the 911 call was sufficiently reliable to credit the allegation that the petitioner's truck ran the caller off the roadway. The court found that the tip was sufficiently reliable because, quote, by reporting that she had been run off the roadway by a specific vehicle, the caller necessarily claimed eyewitness knowledge of the alleged dangerous driving. That basis of knowledge lent significant support to the tip's reliability. The second question, the court also found that the tip created reasonable suspicion of criminal activity because the 911 caller's report of being run off the roadway created a reasonable suspicion of an ongoing crime, such as drunk driving, as opposed to an isolated episode of past recklessness. The key point in Navarrete, then, is that the caller reported firsthand knowledge of dangerous driving based on what had in fact happened to them on the roadway. Going forward to Ms. Pagano's case, it is important to recall that Navarrete also reminded us that, quote, the anonymous tip alone seldom demonstrates the informant's basis and knowledge of veracity. And it is also important to remember that the majority considered the Navarrete decision to be, quote, like White's, a close case. In Ms. Pagano's case, the officer failed to corroborate any evidence of the tipster's conclusory assumption of illegality before seizing Ms. Pagano. The tip itself lacked sufficient guarantees of reliability under Navarrete because it did not present firsthand observation of an ongoing per se dangerous criminal activity. Similarly, under Florida v. JL, the tip did not reliably support reasonable suspicion of criminal activity, which is that second prong, because it was merely a bare assertion of suspected illegality. For these reasons, and for the more state law-oriented reasons in my briefing, the district and circuit courts correctly concluded that Ms. Pagano was illegally stopped. I guess with that, I would open myself up to questions if there are any.
Let's find out. Justice Bernstein.
Not at this time.
Justice Clement.
None at this time. Thank you.
Justice Cavanagh.
For me.
Justice Markman.
I've got one question, please. Counsel, to the best of my recollection, your brief fails even to cite, let alone to analyze, the U.S. Supreme Court's decision in Navarrete versus California. That decision, I think, is the most recent Supreme Court decision concerning anonymous tips and reasonable suspicion. It addressed an anonymous tip related to drunk driving, just as alleged here, and the case was specifically cited in this court's grant order. Do you have any current thoughts on Navarrete? And if you do, why have you chosen not to raise them at an earlier stage of this case?
So Judge, Your Honor, I agree with that characterization 100%. I would attribute it to oversight and error, if not unfamiliarity with the practice at this level, or perhaps a lack of understanding about the court's grant. That's why in my opening statements, I first addressed Navarrete. I consider myself very fortunate to have the opportunity to address those points in that decision today. Had I had it to do all over again, I would certainly, in agreement with Your Honor, make that the major focus of my briefing to this court. I think
All I can say in response, counsel, is that you've totally disarmed me. Thank you.
Well, thank you. I appreciate that.
Thank you. That's all.
Sorry, Justice Zahra?
No questions, thank you.
Justice Viviano? You're muted, Justice Viviano. I was too a second ago.
Sorry about that. Counsel, I have a question or two. I thought Justice Scalia's dissent in Navarrete was interesting and compelling, and you cited it already, but of course, that opinion, his opinion, didn't carry the day because it only garnered 3 other votes. And so it seems to me that these types of anonymous tips, we are to consider them reliable, at least under the Fourth Amendment, when there's a description of a car and its location that's accurate, and I guess even because the tip is phoned in over the 911 system. I was a little more interested in the second part of your argument, which was, I think you seem to think it important that the anonymous tip, the person giving it, has a firsthand knowledge of the criminal activity. Is that right?
That's correct. And I believe that Navarrete, that the majority decision said as much, Your Honor.
The question I have for you is, then let's do a hypothetical. I mean, what if the anonymous tip, the person giving the anonymous tip, watches another individual, do 8 shots of liquor at the bar, and then go out to their car and get in the car and drive off? Would that be sufficient in terms of the person having an idea, although they didn't drive after them down the street, that person is likely violating the drunk driving laws?
Yes, Your Honor. I would agree with that. That would be enough, especially under Navarrete. I think the real distinction that we see between the report in Navarrete and the report in Ms. Pagano's case is the report in Navarrete, the majority opinion considered that data that was provided, that this car, this truck, this whatever, silver truck ran me off the road, that itself presented several indicia of impairment. And Navarrete specifically goes into the different aspects of indicia of impairment that presented. For example, at page 403.
Well, let me just jump in. I agree with your assessment. My question more pointedly is, we don't really need indicia of impairment if we see, or if someone actually saw someone ingest alcohol, right? Because the indicia of impairment is a way of proving that person has alcohol in their system. Isn't that right?
That's right. That's right. And I think that the taking of the shots that you suggested, or the firsthand observation of an amount of alcohol consistent with impairment, would present enough data for somebody to conclude that somebody was impaired.
We don't, of course, have that fact in this case, because the person who called in the tip, I think, at least first of all, the record is very sparse here. We don't have a 911 tape. Was there a 911 tape?
I don't recall if there was a 911 tape. We had the officer testify, not we, I don't know why I said we, but at the evidentiary hearing, the officer testified to the contents that the 911 caller relayed. And the officer...
But you never had access to a 911 tape, is that right?
I have not.
And what about, was there, I mean, again, this goes beyond the record, but it just to satisfy my curiosity, I assume there was a police report that summarized the content of the 911 call. Would that be accurate?
I would assume there would be. I do not have access to trial court discovery presently.
All right, but from the record before us, there's no indication that the anonymous tip person saw the defendant drinking alcohol at the beach or at the park that day. Is that right?
It was a very narrow or slim tip where the tipster reported that Ms. Pagano was yelling at her children, quote, appearing to be obnoxious, and quote, appeared to be intoxicated. And so the correlation to Navarrete is, whereas the court in Navarrete says the conduct there bears too great resemblance to the paradigmatic manifestations of drunk driving. Here we don't have that. Here we have the two indicia of impairment are yelling at children and being obnoxious. And there's nothing more to evaluate the second prong that we need here, which is reasonable suspicion that criminal activity is afoot. Even if we grant that there's sufficient reliability to the tip itself, that the person isn't lying, or that Ms. Pagano will be found at this location, if we find that the tip isn't deficient for those reasons, there's still not enough to reach the second marker, which is that the tip also has to provide reliably sufficient indicia to support a reasonable suspicion that criminal activity is afoot. And so we don't have that here. Here we just have an allegation of appearing to be obnoxious and raising one's voice at one's children in a parking lot. And unlike the way the court characterized Navarrete, those aren't paradigmatic manifestations of drunk driving that would, tend to lead to the inevitable conclusion that Ms. Pagano was in fact drunk driving. Also, unlike Navarrete, accepting the reporter's report here to be sufficient for probable cause would open up any manner or any number of stops. We hear probably too often the terms "it would open the floodgates," but this would lower the bar of reasonable suspicion necessary for a stop, such that those floodgates really would be opened.
Well, I'm afraid, counsel, that horse already left the barn, as Justice Scalia pointed out in Navarrete. But thank you for your answers to my questions. I'm all set. Thank you.
Thank you.
Counsel, Justice Bernstein, you didn't have any at the start. Do you have any now? I don't.
No, but thank you. No, but thanks for asking though.
Okay. Counsel, do you have additional argument, or you want to reserve some time?
I don't have my time in front of me. Does Your Honor?
You can reserve the rest of your time, and we'll come back to you.
All right. I have a few more statements, if I may.
Sure.
In terms of distinctions between Ms. Pagano's case and Navarrete, and also looking back at Florida v. JL. In Navarrete, the response from officers was about 15 minutes later. My understanding is in this case, the response from officers was about 30 minutes later. I would argue that there is no real middle ground between Navarrete and this case. I think the tendency is to try to find a situation that would be allowed by Navarrete, but not allowed under the viewpoint I'm advocating in Ms. Pagano's case. And I don't see it. And the reason I don't see it is because Navarrete, by its own admission, was a close case. It's a 5-4 decision, characterizes itself as a close decision. And I think that if we take anything away from what was relied upon by Justice Thomas and Navarrete, the decision is going to come out a different way. And so when we try to come up with a middle ground between Navarrete and Ms. Pagano's case, I don't think it exists. There could certainly be some hypotheticals, but once you fall below what was at stake in Navarrete or the facts in Navarrete, it's insufficient to support the stop. And that's the case here. Now, I think based on Navarrete, the question presented would be whether the tipster's report presented a sufficient indicia of reliability to support her observations that Ms. Pagano was yelling at her kids and being obnoxious. Under Navarrete, that's what we can confirm the reliability of. And say, is the caller's purported observations of Ms. Pagano yelling at her kids and being obnoxious, is there sufficient indicia of reliability as to those observations? But Navarrete did not involve assessing the credibility of a tipster's theory or assumption of potential criminality. The caller there was run off the road. The caller that doesn't say, I saw X, therefore I believe this driver presents a danger, and there's no inference on the part of the reporter in Navarrete. Then the data is merely, I was run off the road, and from being run off the road, the Supreme Court mines that statement for any number of indicia that would support an inevitable conclusion or a strong conclusion that the driver was driving impaired. Here we don't have that. Here we have to, the reporter has to make an inference or an assumption from those two reported observations that there's some sort of criminality. And that suspected criminality is therefore the reason for the stop here, not the observations of being, quote, obnoxious or raising one's voice at one's kids. For those reasons, and like I said, for the state court reasons and the analysis of barbarage that I presented in my briefing, as well as the analysis of JL and White, I think that the district and circuit courts got it right here. Navarrete doesn't change their decisions, and the stop of Ms. Pagano should have remained suppressed. So thank you.
Thank you. Mr. Wallace. You just have to unmute yourself, Mr. Wallace. I did it myself a few minutes ago.
And thank you. And it's indeed an honor to be here. In terms of the case, I think there's a number of things that we can all agree on just briefly to talk about. That the officer has to have a reasonable suspicion for this stop at the very least. And that when we're not looking at, looking at reasonable suspicion, not probable cause, we have to look at the content of the information possessed by the officer and the degree of reliability. And in doing that, the courts have all stated that we use a common sense judgment and inferences on human behavior. And finally, in that, the broad scope is that it does not have to rely solely on just the officer's observations. It can include other sources. So the questions here really are two, and that's what's been looked at by counsel, is the reliability of the call and then the continuing crime. In terms of the reliability of the call, when you look at Navarrete, you look at three basic principles or three basic things that the court there addressed. One was that the caller had firsthand observation, was an eyewitness to the situation. Secondly, that it was done contemporaneous. The timeline showed that the call came in and the police responded fairly quickly. It was 18 minutes was the time there. And third, the court found the use of 911 as another factor for showing reliability. Well, in this case here before the court, the caller had personal knowledge. They saw, or she saw, the what was happening and called in to report it. And I would note that the way it's described by the officer is that because she had children with her and she was yelling, appearing to be obnoxious and appeared to be intoxicated, that was causing her behavior. So the caller is saying the intoxication is causing the behavior of this obnoxious and yelling that's going on in a public setting. And then secondly, in this case, it's contemporaneous. The call came in at 2:46 p.m. and the car was stopped at 3:11 p.m., so 25 minutes later. And third, again, just as in Navarrete, the call here came through the 911. And I would note as well, follow that up, it's interesting, the court in the People versus Tooks noted that the activity viewed by the informant occurred in public and obviously sufficiently alarmed the observer that he reported the activity to the police. Well, here we have the same thing. This alarmed the witness sufficiently that when that person left, and that's also reported in the testimony there, that the caller thought the person was intoxicated and then left. This alarmed the caller sufficiently that she decided to call 911. And then the other question that we all have been talking about is the criminality. And again, we go back to then what was said in there, the yelling and obnoxious, but that the intoxication appeared to be doing that. So the caller has stated that there is intoxication and then seeing the person drive away. That's obviously a very serious and continuing crime of OWI, or operating while intoxicated. And so you look at what we have here is that all of the innocent factors, the woman driving, the make and model of the car, the color, the license plate, all of those things were confirmed as in Navarrete. And we have here then the whole idea of the criminal activity of showing that she was driving. I would submit that that's ties in perfectly with Navarrete. Two more points real quick and then allow the court to go ahead. One is that when we look at JL does not apply really at all in this case. The issues in JL, Florida versus JL, there was no firsthand observation indicated in that case when the caller reported the gun. Secondly, there's no showing if it was contemporaneous or not. And third, there was no showing of public awareness or understanding how this person know about it. And they didn't use 911 to report it as far as we know. So JL has a wholly different problems in applying. Navarrete, the Barberich case, all these other cases look at, was the person a citizen calling it in with personal knowledge, firsthand knowledge? Was it contemporaneous? And in these cases, they all say yes, as in this case here as well. I'd be welcome to any questions if the court has any at this point in time.
Thank you. We'll start with Justice Bernstein.
Yes, Counselor, good morning. Just a quick question though, is that there was no conduct on the part of the driver as they were driving that would elicit a need for a stop, correct?
That is correct. The officer testified he observed no problems with driving, no reason for the stop as part of the driving itself. But I point out that's true as well in Barberich and Navarrete. They did not see any improper driving there. They based it on that of the other issue. In fact, if we go to that point, if the officer saw the driving, saw improper driving, the officer could make the stop without the call even being a factor, because there's now a violation or a traffic violation or some other activity. And so in that sense, I would submit that you're going beyond the reasonable suspicion and now you're getting to probable cause.
Right. But then at the end of the day too, though, and I hear what you're saying is that you're drawing the assumption that it was the alcohol that created the behavior. And I guess, wouldn't it be fair to argue that it's not totally unusual to see someone yelling at their kids?
I can't argue that for a second, sir, obviously. But I'm not drawing that assumption. That's what the testimony is on the record, is that that's the assumption, that's the statement, that intoxication was causing that behavior.
Right,
So
but
it's
that
not
wasn't,
doing
right, but again, that was the assumption. It wasn't that this individual had smelled, or this individual wasn't able to walk, or this individual wasn't standing it wasn't able to stand up, or wasn't, it was just simply the yelling at the kids.
Yelling and being obnoxious, but yes, I would agree. There's no the statement of this person couldn't stand up, this person couldn't walk, those factors that we typically bring in through an OWI charge. I agree, but the other side is too, Justice Bernstein, that what I would look at is in this call to require those kind of questions. Now we're now making it almost like a mini trial in a sense, with a 911 caller to the person making the phone call that was concerned enough in the first place to make the call.
Right, I understand. Thank you.
Justice Clement?
Yeah, just briefly, draw the line for me on what would be sufficiently reliable tip and what would be an insufficiently reliable tip in this present situation. What took this this anonymous tip and pushed it to sufficiently reliable versus insufficient? What was, in your mind, what's the distinction here?
Well, the distinction that the court in Navarrete made is the three factors that they looked at. It wasn't just the 911 call. That is a factor that the court there looked at, but it was the fact that it was personal observation. It was the fact that it was contemporaneous with the whole situation that was happening. I think it's also a factor that it's Jane Q or John Q citizen making the report, as opposed to someone involved with criminal activity trying to get a benefit. And we know that we can say that, I believe, just because it was a 911 call. It wasn't going and calling the police department on the side. And so I think those are the factors that the courts have looked at now and are finding greater reliance on for finding an anonymous tip, which we have to call that what this is. We have to call it that way based on the record. But that it is those factors that help support that bridge, so to speak.
But in this present case, what was it in that tip that pushed it to that level? I mean, if they had just called and said, I saw a mom, she's yelling at her kids and she seemed, she's being obnoxious, kind of along the lines of what Justice Bernstein was asking, where is it that is enough for law enforcement to say, yeah, there's an assumption or presumption here that maybe she's intoxicated, and then to go, make a traffic stop? Does there have to be something more in that anonymous tip other than I'm seeing someone act, in a inappropriate way or in a way that makes me uncomfortable, but might not be criminal?
Well, and Justice Clement, I would break it into two different points there. As far as one, the question I'm hearing now is not the reliability of the call, but more of the continuing criminal activity. And there's a justification of that theory based on yelling and obnoxious. And I will say, based on that alone, I would submit that there probably is not enough for a stop of just yelling and just obnoxious. But here, the caller took it further. The caller added that point of saying, this person is intoxicated. Now, they're basically said, and that's causing the activity that I'm seeing. But that's the actions, that facts that the witness, the caller, is seeing herself in the situation. And so it's not just the yelling, it's not just the obnoxious, it's the added information that because of the intoxication, that's causing this behavior. And that's what takes it then to the next level, to say there's continuing criminal activity that justifies the officer to make the stop to ensure public safety and make sure that the person is not intoxicated.
Thank you.
Justice Cavanagh?
I just want to clarify. You said that it was her intoxication or the report of her intoxication, but the report is that she appeared intoxicated, correct?
That's what the testimony stated, correct.
Okay, so do you think that that's a significant difference, that somebody is reporting she appears intoxicated as opposed to she's intoxicated?
Well, two different things there. One is the part of the statement is that she appeared intoxicated. The testimony continues on though and says because of that intoxication, she's doing this behavior. And so I think that's a little bit more stronger point there. But secondly, I would also again come back to the idea that here's a person saying, I believe this person's intoxicated. Just take that short version for the moment. And now calling 911 because of it. Concerned enough to say, I'm scared right now that this person's out there driving because it looks like this person's drunk.
Are you assuming her motive though? You're assuming that it was that she made the 911 call or reported and said what she did because of her concern or being scared. I mean, this is the problem with anonymous tips. We don't know what the motive is, right? I mean, what if she hated this woman? What if she was, you know, her, I don't know, some, whatever it may be, but she held personal animosity towards this woman and reported it for that reason. I mean, we don't know that, correct? I mean, all we have are, as the Supreme Court says, we can't rely on in Navarrete, you know, reporting a minor traffic infraction or a conclusory allegation of drunk driving. She has to report a specific and dangerous result of the defendant's conduct. The motive of why she did it or inferring that it was out of concern and therefore that somehow bolsters the belief that she was in fact intoxicated, that motive doesn't really factor into it, does it?
Well, the motive though comes from what she said in the statement. And so I think we can take the motive by her action, by what she said and what was provided on the record. Could she have an ulterior motive? We'll never, obviously we can't say on that part, but based on the record that we had before the court, the motive that would show that she was scared about this person being on the road because she just left. And
her allegation that she was scared, that came where? Can you point to me?
No, I'm using that word, ma'am, Justice Cavanagh. That's my word of using scared. But the fact that we had information that was given to us that she was out of the vehicle to location, the caller was concerned because she had children with her and was yelling, appearing to be obnoxious and appeared to be intoxicated, that was causing her behavior with the children. So the caller was concerned. And that to me is, I'm taking it the next step, I will admit, scared. That's my interpretation of that word.
Okay, thank you.
Justice Markman?
Mr. Wallace, any driver-to-driver observation is likely to be a very passing and transient, involve a very passing and transient observation. Is there any extent to which this should be taken into consideration in determining how to fashion a reasonable rule in terms of searches and seizures in this context? Also, do you have any sense that driver-to-driver observations of the sort that we have in this case, observations which again occur under very exigent circumstances, have been particularly useful or effective in terms of identifying and apprehending impaired drivers?
As to the first question, Justice Markham, I would agree that we hope that driver-to-driver is a brief passing moment in many situations. But in this case, we don't have driver-to-driver. We have someone in the park seeing in the park this activity and then the person leaving. So we even have more than just a passing happenstance here. As far as to answer the next part of that question, and in terms of a rule or that, but I come back to again, what's the detailed information that's been provided that the caller has made? That's always a factor that always has to be given. Just saying a tan car would not be sufficient, obviously. But when you start getting into the driver, you start getting into who's driving, the color, the license plate, and so forth, now we're getting into sufficient details to show reliability.
But you do agree that whatever rule we apply in this case, whatever quantum of evidence we find necessary to sustain a search and seizure here would be exactly the same for a driver-to-driver observation as it would be for a pedestrian-to-driver observation, wouldn't it? Both would be highly transient and passing.
And typically, yes, I would agree with that. Again, here we have before she's even driving, but a rule because of the stop would leave it to the driver to driver or pedestrian that sees a car go by. It would be the more common happenstance. So I would agree with that. And you had a second question, Justice, and I went blank on that one.
Second question has to do with whether, on the basis of your experience, you have any sense that these kinds of observations, driver to driver, pedestrian to driver, have been particularly useful in terms of identifying and apprehending impaired drivers?
That's only going to be based on personal experience, Justice, and I have seen numerous cases in this office where there's been these kind of tips where the officer then tries to find the person, finds them, and has to effectuate a traffic stop. So that it happens, I think, at least in our area, more frequent than not, and has been found to be useful. I am sure there are mistakes made. I cannot quarrel with that for a second. I don't have that information. I just see the end product where the call is made and there's a stop.
Thank you, Counsel.
Justice Zahra?
You know, it seems to me, Counsel, that we're all asking questions in the same area. The intoxication and yelling you say was caused, I'm sorry, the obnoxious behavior and yelling was caused by the drunkenness. And we're of drunkenness in the first instance. In other words, how do we know that the conclusion of intoxicated or appears intoxicated? Because I think someone who could give our reasonable facts behind a conclusion that I believe they appear intoxicated would give rise to a reasonable suspicion. But do you have any cases at all, where just the conclusion that the person appears intoxicated was enough to give a reasonable suspicion?
I'm not aware of any cases at that point, Justice Zahra. Excuse me, Zahra. I mispronounced your name there, I apologize. But I'm not aware of any cases offhand on the top of my mind at this point in time, no, sir.
Okay.
But I am saying that, again, based on all of the facts before the court, that's sufficient in this situation.
All right, thank you.
Justice Viviano?
Oops, thank you. Counsel, I have just a couple of questions. I'm concerned about the inadequacy of the record in this case. And first of all, I'm a little rusty, but my recollection from my trial court days is that the prosecutor has the burden of proving the lawfulness of the stop once it's challenged by defense counsel in a motion, like in this case. Is that right?
Absolutely.
And that usually results in a hearing where the prosecutor calls a witness and then puts the witness on a direct examination to make out the proofs, right?
And if I might, I recognize my time's gone out, but if I have permission to go ahead and respond to the court.
Please.
So yes, that would be the normal process. Actually, in this case, the defense called the officer as the witness and then was presented with the testimony that was provided.
But as a result, we're sort of limited by this one answer elicited by the defense counsel that we're all picking apart to try to determine whether it's sufficient to show reasonable suspicion that criminal activity was afoot. You refer to it as the ongoing criminality, but really whether there's reasonable suspicion in this case to justify the stop, right? We're limited by this one sort of rambling answer that the deputy gave in response to the defense counsel's question, right?
Based on the continuing criminality or ongoing, yes, I believe this is the main answer that provides that information.
Let me jump in. Was there no 911 tape?
There is a 911 tape. It was recorded. I've listened to it, but of course, it was not made a part of the record by the prosecutor that handled the case, so I'm not referring to it naturally.
Right. No, I understand that. I guess and there likely was a police report, or maybe just was from that tape. But if you if you read on to the transcript, it's sort of interesting to get into the argument section of this transcript. There's reference to some other facts, I guess, that again may not necessarily be before us, but it appears that there was some slurring of speech that's sort of repeatedly referred to by defense counsel, which makes this hearing even stranger. So the prosecutor didn't put in the evidence the prosecutor should have put in. Then when defense counsel's arguing, defense counsel's alluding to facts that are not in evidence to her client's detriment, like the fact that this person, their speech was slurred. And I think that also some reference to the view of this person, not just appeared intoxicated, but was wasted. And I guess I'm concerned that we're limited by this answer in deciding this case, and I suppose that's the way it goes. But is there any reason why, or do you have any idea why the prosecutor didn't put in either the 911 tape or even ask the deputy some follow-up questions to establish what the reasonable suspicion was in this case?
And unfortunately, no, I don't have the answer to that question.
All right, so we're just sort of picking apart this one answer to see if it's enough, but it may not actually reflect what happened in this case.
I think that's a very fair statement.
One last point. Justice Markman was asking you about sort of pedestrian to driver or driver to driver observations and what standard applies and whether it's different. But really, the reality is in this case, this individual was probably in the best possible position to observe whether somebody was drunk or acting erratically, because she was viewing that individual not inside a vehicle, not inside a moving vehicle, not with her inside a moving vehicle, but presumably while they're both in the parking lot at the beach. Is that?
And that is our position, that based on being in the park and seeing the person and having a chance, and actually be on the phone saying that the person's leaving, we believe all goes to, it's more than just a brief happenstance occurrence here. It's where the witness had the chance to observe all these actions.
Okay, I mean, I guess the point is only that there would be an even better vantage point to see what was happening. I'm not sure if that increases or decreases the reliability of the tip, but in terms of viewing whether there's criminal activity, this person's actually probably in the best vantage point of the scenarios we've been considering. Okay, thank you, counsel.
I would agree.
Your time is up, Mr. Wallace. Mr. Horowitz, do you have any rebuttal?
Yes, Your Honor, thank you. Justice Viviano, I would begin with your question about the caller in this case being in the best possible situation to make observations that could support a reasonable suspicion. And I disagree that the caller here would be in a better situation to make a report than the caller in Navarrete, because the caller in Navarrete was specifically driven off the roadway. Now, in Navarrete, as Justice Thomas characterizes it, the 911 caller in this case reported more than a minor traffic infraction and more than a conclusory allegation of drunk or reckless driving. Instead, she alleged a specific and dangerous result of the driver's conduct, running another car off the highway. The conduct bears too great a resemblance to paradigmatic manifestations of drunk driving to be dismissed as an isolated example of recklessness. Running another vehicle off the road suggests lane positioning problems, decreased vigilance, impaired judgment, or some combination of those recognized drunk driving cues. And so what we see in Navarrete is the action witnessed, the dangerous action witnessed by the reporter having been run off the road, is therefore indicative of all these indicia cited by or enumerated by Justice Thomas that lead to the conclusion of impaired driving. We do not have that in Ms. Pagano's case. In Ms. Pagano's case, we have the quote that she was yelling at her children, appearing to be obnoxious, and appeared to be intoxicated.
What if, Counsel, let me jump in. What if we had a little bit more? What if we had the tipster say she was slurred in her speech and her eyes were watery? Would that be enough?
I think that would present a closer call. I don't know that it would be enough, but I think it certainly gets
those are classic indicia of somebody being
absolutely. Absolutely. I think that gets to the question that here there's no real paradigmatic, as Justice Thomas said, or as Your Honor states, classic indicia of impairment. There's no indicia stated so that we can determine the reliability of the caller based upon. The only indicia are obnoxiousness and yelling at children. And then there's the bare assertion of criminality or the conclusory statement that she's appearing to be intoxicated. And in that respect, this looks a whole lot like what we see in Florida v. JL, where there we have innocuous details, the type of shirt the gentleman was wearing, that it was a Black young gentleman or child, I suppose you could say, that he would be at a particular location. I think those would be akin to the innocuous or non-impairment indicia in Ms. Pagano's case, where you're saying that she's appearing to be obnoxious, that she's yelling at her children. And then in JL, the caller then asserts the conclusory statement, and by the way, this young man has a gun. And in this case, the caller says, and by the way, she appears intoxicated. And I think for those reasons, this case really does mirror the structure of JL and the insufficiencies of the tip in JL. Now, I also wanted to point or just...
Mr. Horowitz, I'm going to have to interrupt you. Your time is up. Justice Viviano, did you have any follow-up questions? I don't want to cut you off. I am going to cut you off, Mr. Horowitz. Sorry, different rules.
Yeah, I do not. Thank you.
Okay, thank you very much.
Actually, can I ask a quick question?
Oh, yes, you may.
Thank you.
As long as it's quick.
It's good. I promise you it will be. Counsel, just if you could just help me to understand or to make reference to what brother counsel argued, which was that for every call that comes in, it's going to create a mini trial where basically, there's going to have to be a certain mini trial for every 911 call that's made. How would you address that in terms of the implications of this on people making tips and what that would actually require a caller to do who's trying to put forth some type of a tip on a situation like this?
I think that situation has been the situation throughout the history of these cases, at least since we started requiring indicia of reliability and veracity. It's already been that case, and there's no onus on the reporters, right? The reporters, I don't think that we need to view them as what can they do enough to affect their mission, right? Mm-hmm. They're just making a call, and whether or not their call is sufficient enough is a different question. If the person feels concerned, or the person feels angry, or the person feels slighted, then they make the call. Now, the other thing is the caller doesn't have to make the call anonymously. As the concurrence in, what was it? The concurrence in Florida v. JL said they were really talking about when telephone calls are truly anonymous, the informant has not placed his credibility at risk and can lie with impunity. And that's the concern. Mm-hmm. And so you're looking at something to rebut that possibility. I think first and foremost, if the caller wants to put their stamp on it, they can. Hi, this is Mike Horowitz. I'd like to make a call about somebody I think is drunk. I think this person's drunk for these reasons. Of course, the tips are rarely going to sound like that, But
Right.
whether or not it devolves into a mini trial in any case, we already have the ability to, upon a proper showing, have an evidentiary hearing in any criminal case involving an anonymous tipster. It's not going to change the equation much one way or the other. If anything, applying Navarrette's relative relaxation to this case would change the status quo in the other direction. But
Justice Bernstein, does that answer your question? I'm sorry to.
No, it does. Thank you, counsel.
Okay. Thank you, counsel. The case will be submitted. We will be back in, sorry guys, you have 8 minutes to get your lunch.